Next, Alan Koenck is back to talk about post-grant review and prior art submissions under the American Invents Act.
I see it's a standing ovation already for me. Thank you. Oh, wait, no, that's more of a walking ovation, isn't it? Well, thanks for those of you who are still interested. Thanks for sticking around for my second talk this morning. I'm kind of bookending the morning here with AIA topics, and certainly for those of you who practice patent law, I suppose this is pretty interesting. For those of you who don't, we'll see if we can make some of these topics interesting and topical for you as well. So, a patent issues, and it's somewhat relevant to something that you or your client is doing. Kind of the question that can be considered or raised is, well, what can you really do about that? How do you deal with the potential of what looks like could maybe work itself into a patent infringement situation for your client? And historically, you've always been able to challenge the validity of patents in a court proceeding. Certainly, if you're sued for patent infringement, a defense to that could be that the patent is invalid by virtue of it being obvious in view of prior art, by virtue of a number of other kind of legal challenges that can be made in that context. The thing about court challenges, though, is that there has to be a ripe issue for a court challenge to be taking place. So obviously, being sued for patent infringement brings the case in, and that issue is ripe. So certainly in that context, but if you're not yet sued for patent infringement, you really have to have a colorable threat of suit of infringement to bring a declaratory judgment action in court. And that oftentimes may not have happened, and yet you're aware of a patent and you have a concern about how it might apply to you. So that's certainly one scenario where you might want to have some kind of administrative review of a patent that's issued to clear up these issues before they become something that's a threat of infringement for you. And the other time where administrative reviews are often used is kind of in conjunction with litigation. And in particular, for a defendant who's sued for patent infringement, filing a request for an administrative review in the patent office can be an effective way to stay that litigation, slow things down, and basically have the litigation wait until that administrative review is complete before that case can proceed. And so those are kind of the two main times where these administrative reviews are useful and strategic. So under the AIA, we have actually an expanded list of ways you can initiate administrative reviews of patents. And really the first one on this list kind of doesn't fit with the others because it's done before issuance of a patent. There's a procedure under the AIA where third parties can submit prior art to the patent office while the patent application is still pending. Get the examiner to consider that art in the process of examining the patent so that, in theory, you can get the most relevant prior art in front of the examiner and prevent a bad patent from even issuing in the first place that might be a problem for you. Supplemental examination is actually a procedure after a patent grants that's initiated by the patent owner to allow additional prior art to be considered with respect to that patent. Post-grant review and both ex parte reexamination and inter partes review are all administrative reviews of issued patents, and they have kind of different characteristics, and we'll walk through in a little bit of detail what those involve and when you might want to use those different types of procedures. So just to give you a sense of how often the different vehicles are used for administrative review, there's some statistics that the Patent Office has put up that are current through the end of April. This covers about 7.5 months of time that these tools have been available for use. So these pre-issuance submissions where a third party files prior art in a pending patent application, have been used just over 600 times over the first 7.5 months. So that's a fairly active use of that. I have seen some numbers that have indicated that the percentage of times that the examiners are adopting essentially the suggested rejections of claims in those pre-issuance submissions is something on the order of about 25%. So not maybe as high as you might have thought. Having not been able to kind of see what those submissions are and compare which ones are being adopted and which ones aren't, it's hard to draw too many conclusions at this stage on how effective that procedure can be. But certainly it's something that's being used. In fact, it's something we've done in our office for clients as well when they spot published applications where they see claims and they think, you know what, I know that's been done before, I've got the documents, I'm going to submit those to the patent office so that claims like are pending in this case don't come out and cause a problem for me. Supplemental examination, again, this is the one requested by the patent owner after a patent grants, has only been used 18 times so far. This is the one that was expected to be used the least of all of these procedures, because it essentially is really only relevant if the patent owner discovers some prior art that they knew about or should have known about and didn't cite to the patent office. And so after the patent issues, they can kind of correct that situation and get that art in front of the examiner so that there isn't a problem later on with prior art that they knew of not being submitted. So that's the major use of supplemental examination. Inter partes review is a third-party initiated administrative review of patents. Essentially, this is the one 2/3 of the time when these are filed, it's filed with respect to patents that are already in litigation. So it is tended to be a way to get a validity determination in the front end of a court case without having to go all the way through and do that in the actual litigation. Some think it to be a little less expensive. Some think it to be a little more patent owner friendly, third party friendly, patent owner unfriendly. So that's what it's typically used for. It's on a pace with 215 filed over 7.5 months. It's being used very similarly to inter partes reexamination, which is what this procedure replaced. And they're very similar. Again, it's a third-party proceeding where both the patent owner and the third party are participating, sending arguments back and forth to the examiner, or in this case to the Patent Trial and Appeal Board, and the decision is made with both parties having input. And finally, post-grant review. This proceeding is currently only available for any patent application that was filed after March of 2013, which, if you remember from my pendency statistics that I talked about earlier this morning, patents that are filed in March of a year are not going to issue in June of that same year. It's going to take much, much longer than that. So the only patents that are really being covered under this post-grant review are patents that deal with covered business methods. So there's a specific part of the legislation in the AIA that says post-grant review applies only to these patents filed after March of 2013 or to patents that have claims that cover business methods, because we want this to be available for those kinds of patents because there's kind of specific problems at play in those. So for 7.5 months, 21 of those have been filed with respect to business method patents. As of June, that number I read had gone up to 28, so it's kind of on a fairly steady pace. And there's been one decision, which I'm going to talk about at the end of my talk. It actually came out on Tuesday of this week. So as I mentioned this morning with my talk this morning, I didn't have to do any last-minute prep, but for this one I actually kind of did. So we'll go through that, and it's a pretty interesting scenario to talk about. So real briefly, how do you use each of these tools to get these reviews done? A third-party prior art submission, this is during pendency of a patent application again, has to be filed after the application is published. That makes sense. That's how you find out that there's any claims that you want a review done. It has to be filed within 6 months of that publication or before a first office action from the Patent Office has been issued, whichever is later. So, as you might imagine, you look at that kind of a time window. If you're going to use this as a strategy against competitors to watch for patents that you would like to be kind of sending prior art in and influencing the examiner's decision in issuing patents, you're going to have to be monitoring publications on a fairly regular basis. You'll have a 6-month window after publication to file. So you should be, any monitoring system you use should be at 6 months or less to catch everything and get it in the window. The submission that you send in is a listing of the prior art that you want the examiner to consider and a concise description of the relevance of that prior art that you send in. It can be in the form of a claim chart, but it cannot be a proposed rejection of the claims. So you kind of, for those of you who have done claim charts before, you can imagine that that's going to look a lot like a proposed rejection of the claim without using that exact language. So I think a claim chart is a pretty effective way to present this to the Patent Office. So they get basically kind of a visual view of which elements of the claims you believe are shown by which of your prior art references that you send in. Supplemental examination, briefly on this one as well, filed by the patent owner after issuance of the patent. It can be based on prior art or information that is printed publications or other information that is not a printed publication, like for sale, like those kinds of things that are not necessarily published documents that might raise a new question of patentability. And if the Patent Office finds that there is a new question of patentability, this will go straight into an ex parte reexamination, which will just be between the Patent Office and the patent owner, deciding whether the patent is still valid, whether the claims need to be changed, what needs to happen. Ex parte reexamination, as I alluded to, it's just between the patent owner and the Patent Office. However, it can be filed and instituted by the patent owner or by a third party. If a third party institutes an ex parte reexamination, they essentially just kind of start the process and then they're out. They just watch from the sideline and don't participate. The substantial new question in a regularly instituted ex parte reexamination must be based on a patent or a printed publication. These typically take over 2 years to be concluded, and statistically, in most cases, the claims end up being changed or canceled in some way. So these are usually brought for reasons where the prior art is, has an effect on the claims. That would make sense if you want to go through this process. Although 1 case out of 5, roughly, the claims will survive exactly as they are. Obviously difficult to predict based on those statistics how an individual case will come out because the facts are very divergent in these kinds of cases. Inter partes review is one of the new proceedings. It's similar to inter partes reexamination, which we've had for quite a while. It involves participation, again, from the patent owner and the third party who started this proceeding. It can be filed 9 months or more after a patent issues or after a post-grant review has been completed, if there was one. It cannot be used more than 1 year after you've been served with a complaint for patent infringement. So if you get in litigation and you want to do an administrative review challenge of the patent that's involved, you need to file that in the first part of that litigation within a year of the complaint. Inter partes reexamination took, on average, 39 and a half months to complete. Inter partes review is supposed to take about a year. So that is actually maybe the biggest change of all in this procedure. It's going to go much more quickly. And again, there's some statistics on what happens to the claims in these cases. Post-grant review, we talked about this just for a little bit about when it's available. It's patents filed after March 16th, so none of those are issued patents at this point and won't be for some time. So other than business method cases where it's available right now, we're going to be waiting quite a while for post-grant reviews to really start happening. You can challenge based on any grounds of unpatentability, not just novelty, which is Section 102, and obviousness, which is Section 103. And again, this is a procedure that's supposed to take place in a year or less. So let me just give you a little information about the case that came out on Tuesday, which was SAP versus Versata. Versata, in this case, had a patent on a method of pricing products and services, and they sued SAP for patent infringement back in 2007 on that patent. Went to the district court. The district court found that the patent was valid and was infringed and awarded damages and an injunction against SAP. SAP appealed that decision on the basis of the damages and injunction being improperly decided. Interestingly, the validity of the patent was not one of the issues that was on appeal in that case. The case was remanded back to the district court for some further hearings on the damages and injunction issues, finding that the injunction was too broad and that the damages needed to be redecided. And in the meantime, the AIA came out in 2012, and SAP filed a post-grant review against Versata's patent, claiming that it was invalid under Section 101, which is statutory subject matter, saying that this was related to abstract software and wasn't a patentable invention in the first place. Under 102, saying it wasn't novel, and under 112, saying that there were formal problems with the case. So that was decided by the Patent Office Trial and Appeal Board, and they said that there were issues that needed to be decided with respect to 101 and 102, not with respect to 112. So they granted the post-grant review for those two grounds of rejection. SAP asked for an expedited trial, and in exchange for that, they agreed to forego their 102 claims. So this trial went forward just on the issue of 101, whether these were patentable subject matter, the software that was involved. And in fact, in the decision that was issued earlier this week, the Patent Trial and Appeal Board found the claims to be invalid under Section 101. These were the claims that had been found valid by the district court and infringed. There was a claim construction in the district court that was done that wasn't actually even appealed. The Patent Office applied the broadest reasonable interpretation standard that those of you who practice in this area are familiar with the Patent Office doing, which was different than what the district court had construed, but they didn't have to give that construction any deference in this proceeding because it was unrelated to what the district court was doing. So SAP walked out of there with a decision from the Patent Office that the patent claims that they brought on appeal or that they brought a post-grant review of were invalid when the court had found them liable for infringement. So we're not done hearing about this. That decision is pretty sure to be appealed, and it will be relatively interesting to see what the Federal Circuit says about kind of this whole issue of the court and the Patent Office doing different claim constructions using different standards, and whether, if there's litigation that should have any effect on these post-grant reviews. I think that'll be an interesting thing to follow, and one thing you can probably expect is that next year, if you come to our seminar, I might have something to say about it and talk about it. So, thank you. You've all been here now for almost 4 hours. You're probably a little hungry at this point. So we're going to dismiss you for lunch. I'm going to have Katie come out and tell you all about how the logistics of that work in terms of when to get back for the afternoon part of the seminar. But thank you very much for your attention, and appreciate it.